Hello friends, in the series on the income tax cases, today we will discuss a very important issue on the issue of notices under section 148 and then completing the assessment under section 147. Already the proceedings under section 147 read with section 148 are very complex and there are a number of steps. And at every step, there becomes some legal point, the benefit of which even the department can take and we can also take. This case is also the perfect example of that how important the legal grounds are in the income tax proceedings. The issue involved is that whether assessing officer can issue notice under section 148 when there is time to issue the notice under normal scrutiny proceedings under section 143 subsection 2. This issue has been taken by Honorable Bangalore Tribunal in the case of UBMC Trust Association versus Income Tax Officer Exemptions. This case has been reported in 111 ITR Tribunal short note 66 and the date of the judgment is 8th April 2024. In the present case, the assessee is an NGO and the assessee has not filed the income tax return for the two assessment years, that is assessment year 14-15 and assessment year 15-16. When the learned assessing officer noticed this thing, the assessing officer issued notice under section 142 subsection 1 to the assessee to file the return of income. When this notice was issued for filing the return of income, the assessee filed its income tax return for both the years on 2nd December 2016. This date is important. Now, if we see section 143 subsection 2, which is there to trigger the scrutiny proceedings and talks about the time up to which the notice under section 143 subsection 2 can be issued to the assessee. That section says that the notice under section 143 subsection 2 is to be issued within 6 months from the end of the financial year in which the return of income has been filed by the assessee. Now, the assessee has filed the return of income in the financial year 16-17. So, if we count 6 months from the end of the financial year 16-17, the date comes 30th September 2017. So, in the present case, since the assessee has filed the return for both the assessment years on 22nd June 2017, so for both the years, the learned assessing officer has the time to issue the notice under section 143 subsection 2 in respect of return filed for both the assessment years. But the learned assessing officer didn't go for section 143 subsection 2 proceedings for the normal scrutiny, but directly jumped to section 148 proceedings and completed the assessments. When the matter was pending before the learned CIT appeal, the assessee took the ground that in the present case the assessment is bad in law because directly section 148 notices were issued when there was time for the assessing officer to issue the notice under section 143 subsection 2 in respect of the return filed in response to the notice under section 142 subsection 1. The CIT appeal said that since the assessee has participated in the assessment proceedings, so this ground is not valid. But the inference can be drawn from this thing that even the CIT appeal admitted that section 148 notice cannot be issued before the time when the time is there to issue the notice under section 143 subsection 2. The assessee carried the matter to the tribunal and the tribunal said that in the present case, on date of issue of notice under section 148, original assessment proceedings were pending as time for issue of notice under section 143 subsection 2 has not expired. In real sense, there were no section 143 subsection 3 proceedings. Normal scrutiny proceedings were not going on. But the tribunal said that if the time to issue the notice under section 143 subsection 2 has not expired, then it can be deemed that the proceedings are pending. The tribunal also said that section 142 subsection 1 and section 148 cannot operate simultaneously. The tribunal concluded the matter by saying that there was no need to issue the notice under section 148 in the present case, and hence the assessment done for both the assessment years on the basis of issue of notice under section 148 is bad in law. At the end of this video, once again I am repeating the name of the case. The name of the case is UBMC Trust Association versus Income Tax Officer Exemptions, and this case has been reported in 111 ITR Tribunal short note 66, and the matter has been decided by Bangalore ITAT, and the date of the judgment is 8th April 2024. Thank you, friends.